I'm talking today with Lucy McPherson, who's an alumnus of Southern Cross University's Law School and is currently a partner at Atwood Marshall, a commercial law firm based on the border between New South Wales and Queensland. And since commencing her career in 2010, she's come to specialise in the area of wills and estates and succession law. And she holds a Masters of Applied Law from the College of Law in that subject area, and also speaks regularly at professional development seminars run by industry bodies such as the Legal Education Television Network. Thank you, Lucy, for making the time to talk with us today.
My pleasure. Thank you for having me.
I thought I'd start just by asking about your current position. How long have you been with Atwood Marshall, and what kinds of matters are you involved with at the moment?
Okay, so I'm the partner of our estate litigation team at Atwood Marshall Lawyers. So I lead up a team of 6 lawyers who work exclusively in the area of estate litigation. So estate litigation is, I guess, an umbrella term that encompasses a lot of different types of matters. Any matter that's contentious, really, in relation to a deceased estate. So matters concerning capacity, surrounding the execution of a will, family provision applications, matters relating to undue influence and suspicious circumstances in relation to the execution of a will, and really any matter that involves a dispute in relation to a deceased estate comes to our team. I've been with Atwood Marshall now for over 10 years. And have worked my way up from senior associate to special counsel to now partner of our team.
And how did you come to specialise in wills and estates law? I
never really saw myself in a commercial or corporate area of law. Being a naturally empathetic person, I wanted to help people in their personal lives. So I tried a few different areas when I started in practice, and when I stumbled across wills and estates, I really fell in love with the area because you're exposed to, I think you're exposed to a number of different areas of law within the umbrella of wills and estates. So you will get exposure to property law issues or family law issues, for instance, when dealing with the administration of a deceased estate or in the area of estate litigation as well. So I guess you could say I stumbled across the area, but when I found the area, I really loved it. And I've been practising exclusively in this area now for, it'd be about 14 years.
And just in terms of, you mentioned empathy, in terms of the personal qualities that you would say are necessary to do what you do, and I suppose to be a successful lawyer in this particular area, or if you have any thoughts about lawyering generally, that's also interesting. But I'm really firstly interested in the qualities that you think help lawyers working in this area.
That's a great question. I think strong communication skills is essential, not only in this area of law, but in any area of law. And emotional intelligence or empathy, the ability to be able to understand how these decisions are affecting your client's, emotional well-being, as well as, having an eye for their commercial or financial interests as well. It's difficult, really, to have that, but it's really crucial in this area of law. And also with respect to the communication skills, it's our role as lawyers to explain very complex legal issues to our clients. And in order to do that, you really need to have strong communication skills, the ability to reduce very complex legal issues to a language that's going to be easily understood. But I think it goes beyond that as well, because especially in this area of law, when you're dealing with really complex family dynamics, you need to have that nous about you with respect to, having communication skills to deal with those very difficult situations that can arise. So To answer your question, I think empathy, communication skills, and also meticulous attention to detail is something I think is very important. A very small or intricate detail that's missed or overlooked can have really catastrophic consequences in this area of law. So I think that it's really important to have that attention to detail as well.
Yes, look, I'm having some familiarity with the area. I'm just sitting here nodding my head. I think that's a great summary of what's needed. And just if I can take you back to when you first started practicing. So that was, am I right? It was 2010?
Yes, that's right.
What are your memories about transitioning from being a law student to practice? Do you have any vivid recollections about perhaps any surprises or rude shocks along the way about making that transition from law student to legal practitioner?
So many.
What, rude shocks?
So many rude shocks. I think that, studying law is very different from practicing law. And although my university studies certainly set me up in terms of learning analytical skills and critical thinking skills that you need in practicing law, there are a lot of skills that you just simply cannot learn at university that you need to learn in practice. When I think of rude shocks, that's what I'm thinking of. It was a significant learning curve to gather those skills along the way. What I'm talking about there is, things like managing client expectations, having that eye for a client's emotional needs as well, because I think in law school you're focusing on the content. You don't have a client in front of you, so you're sort of thrust into this world where all of a sudden you're dealing with real people, and there are a lot of additional skills that you need to acquire along the way. Yeah.
So a steep learning curve.
Yes, absolutely. Particularly in the very early years, I think that was one of the most difficult things for me, was to sort of get my head out of the content of the law into, dealing with real life situations with real people in front of me.
Yes.
Yeah.
Yes. In general, do you think it's, for where you are now, for example, in your career, is it possible to achieve a really good work-life balance, and how has that changed from when you started practicing? It's often kind of, I suppose, an urban myth that lawyers starting out, especially in commercial practice, are really required to work long hours, and there's even a perception that all lawyers are working long hours, or that the work-life balance is hard to achieve. I'm just wondering about your own insight into that.
That's a really good question, and I think I'd like to answer that question in two parts, because I think, first of all, the industry has changed quite significantly in the time that I've been in the industry. I think that perhaps COVID had a little bit to do with that shift. But certainly at Atwood Marshall Lawyers, we promote a work-life balance. We don't want our paralegals and our junior lawyers and our staff, staying back well into the evening. If that's happening, that's an indication to us that something's wrong. Something needs to be corrected. It's something, I think, industry-wide as well, that's sort of moving that way to promote that work-life balance. So that's the first thing I wanted to say about the shift in the industry. I have seen it. It's slow, but it's happening. And personally for me, yes, it is possible to work in the law and to hold a senior position and have a work-life balance, although it does take intentional effort and discipline, I think. And what I mean by that is, personally for me, setting very clear boundaries, both at work and in my personal life, is crucial to having that work-life balance, and managing your time and being very organised so that, I can spend time at home with my two young children, and I can get exercise in every day. All of those things are really important. And, you know, having that intentional discipline goes a long way to making sure that you can have a life where you've got that work-life balance. Yeah.
I think it used to be perhaps the exception where a law firm would cultivate that, but I'm hoping that you're suggesting it's perhaps becoming a bit more widespread in the industry generally.
My experience is that it is.
Well,
yes.
that's good news.
Yes,
That is good news.
Definitely.
If I could turn to succession law itself and the practice of succession law, just talking about change again. Looking, for example, at family provision matters, you know, disputed wills, disputes in families, etc. Have you seen a change since you've been in this area in the way these matters are managed by the court, first of all?
Yes. So procedurally, there has been quite a lot of change in the area that I practice in over the period that I've been working in this area, particularly in the court case management procedure. There's been a lot of change over the years in both New South Wales and Queensland. So because I'm based on the border, I do practice in both the New South Wales jurisdiction as well as in Queensland. And in both of those jurisdictions, there's been quite a lot of change in the procedural aspects of the matter. Yeah. Similar
change in both states? Is it a marked difference when practicing in one jurisdiction as opposed to the other?
It is very different, in fact, procedurally. And Queensland, actually, there hasn't been a lot of change until very recently. There was a new practice direction issued in June this year, which is strikingly similar, in fact, to a practice note that was in effect in New South Wales only a couple of years ago. But in New South Wales, there's been a lot of change over the years, from having the family provision list managed by registrars who are judicial officers of the court, to then shifting to having family provision claims judicially managed by a judge, to then shifting back to having the matters managed by a registrar. So there's been sort of toing and froing that's occurring in the court case management procedure.
Interesting. And would you say that the predictability of judgments has changed in the sense that, do you think you can see the pendulum swinging any one particular way? You know, it's either, well, I'm not sure of an example, but do you find that the interpretation of the succession law, I suppose I'm thinking of the notional estate in New South Wales and the generosity perhaps of family provision or orders. I'm just wondering if there's any change in that interpretation, or is it a consistent area of law in terms of judicial interpretation?
Look, I think that it is not predictable, no. And I think the reason for that is it's a very discretionary area of law. What I mean by that is that you could have two cases that have strikingly similar fact scenarios, but have them considered by two different judges, and they could come up with a completely different outcome. In fact, that happened in 2012. There were two decisions that were considered by the New South Wales Supreme Court that had strikingly similar fact scenarios. Two judges came up with completely different outcomes. So it's a very discretionary area of law, and that creates a lot of uncertainty for the profession and for clients as well.
Yes.
Because myself in family provision law, it's very difficult to advise in relation to possible outcomes when the exercise of discretion is so wide by a judge. And for that reason, we will only ever advise in ranges of possible outcomes.
Yes.
Rather than specific outcomes, because it's just far too difficult because of that discretionary element of the law.
Look, I remember I worked a lot with the Civil Liability Acts, and mostly New South Wales, but in Queensland. Firstly, I noted how vastly different they were, but also it put a focus in, say, negligence matters, really on settlement negotiations and on settling and on strongly advising clients to really seriously consider settlement. How much of your job would you say is, broadly speaking, mediation, as in focusing on settlement negotiations as opposed to court advocacy?
I'd say that about 90% of my matters would settle by way of negotiation or at mediation. Yeah.
Yeah, that's interesting. Yes.
Yeah. A significant portion of my work settles by way of negotiation, whether at a mediation or a settlement conference or shortly thereafter. And I think that has a lot to do with what we were just discussing. There's a lot of uncertainty when you go to court before a judge. And it's also very expensive. And I think those two factors are significant motivating factors for clients to consider reaching a resolution with the other side before it gets before a judge. And I think that, clients like that, in my experience, because at a mediation or a settlement conference, the control of the outcome is in their hands, in the sense that they can say yes or no to an offer that's been made. If you go to court before a judge, the control is completely out of their hands. The judge will impose a decision on the parties, and that's very frightening for individuals, particularly when there is this discretionary element of the law. So in my experience, I think that's why so many matters will settle at mediation or by way of negotiation. Yeah.
I'm thinking now of the impact of the ageing population generally, and we focus a lot in the unit studying wills and estates. We focus a lot on the issue of capacity, and I think students find it a little difficult to believe how much work you have to do in order to protect a client from challenges to their will, just in terms of once they are elderly, that capacity is always a live issue. And I'm just wondering, in terms of the ageing population and the clientele that, the matters that where you're either drafting wills with elderly people or advising generally on succession matters in relation to ageing, powers of attorney and enduring guardianship and so on. Is it becoming more of an issue, capacity, in your experience in the practice, or is it pretty much the same as it ever was?
I think that the ageing population is certainly shifting the nature of the work that we do, in terms of there are more matters that relate to issues of capacity, particularly around drafting wills and enduring powers of attorney or enduring guardianships. Part of my practice is in that area, that I guess I'll call it a corresponding area of expertise in guardianship, financial management and financial administration, because a lot of these matters that I'm dealing with respect to capacity may have to end up before a tribunal in relation to, obtaining an order for financial management or financial administration. So it is becoming more prevalent, I think, to be dealing with these issues surrounding capacity. When it comes to issues of capacity in drafting a will, I understand what you mean when you said your students, are a bit surprised by this, because there is a lot placed on the solicitor that's drafting the will, in terms of making sure that they are asking the right questions, perhaps obtaining medical evidence in relation to that person's capacity if there's going to be some doubt, keeping very detailed, meticulous file notes about their attendances on that individual. There's a lot that needs to be done by the solicitor that's attending on a will maker in those circumstances. And the reason for that is that all of that material that I just mentioned is what a court would consider if that will is ever challenged. So I deal a lot in the area of challenged wills on the basis of lack of capacity. And the crucial evidence for a judge is going to be medical evidence, particularly medical evidence that's in close proximity to the date of the will, because there is, acceptance that capacity can fluctuate over time. Somebody might have a good day and a bad day in terms of their capacity. And also evidence from the solicitor who attended on that person to make their will. That's the evidence that the court has most regard to. I mean, other evidence may come into play. But that's why it's so important to make sure that that documentation is in order, because if the will is challenged, that's what the judge really wants to see, you know, that evidence from the solicitor who attended on the will maker.
Yeah, look, from my perspective, it's just great to hear you confirming those things or saying those things, which we do focus on a lot in the unit as well. Is it fair to say that capacity is, you know, the elephant in the room? It's like when you're talking about torts. Well, negligence is just the huge tort that that affects, you know, the Civil Liability Act and matters generally. Is capacity the single biggest issue that you deal with in terms of disputed wills and legal argument? Is it they around capacity mostly, or
actually
not?
No? It's certainly a substantial part of my practice, but family provision applications are definitely the most, in terms of the work that I do, the most. So adult children challenging wills, really, that's the category of family provision applicant, I guess, that's most common.
Yes.
Adult children of a deceased person, makes up, I think, probably, I estimate 50 or 60% of the work that I do. Yeah, so capacity is a large part of the work that we do, but I think that family provision applications is probably more common.
Well, is there anything else that you might think of to mention to our students? I'm just throwing the ball back in your court, I suppose, Lucy, just asking about the practice of succession law. Is there anything that I've perhaps missed, or anything you want to emphasise when talking to students studying law generally and this area of law?
Look, I guess as and to anyone who's thinking about working in this area, I'd say that I thoroughly enjoy it. The reason is that I thoroughly enjoy it is that I find it very intellectually rewarding, in terms of the variety of work that I do and the academic side to the work that I do as well. But also it's very rewarding on a personal level, because I am helping people and changing their lives, helping them change their lives for the better. And that is just, you know, why I gotta get up out of bed and go to work in the morning, is so that I can affect change in people's lives in a positive way. That's why I chose this profession, but even more so because I'm working in an area that affects people's personal lives. It's very rewarding.
Well, Lucy, thank you so much for talking with us today.
You're welcome. Thank you so much.